Hi, I'm Paul Pfeiffer. I'm board chair of Migrant Center for Human Rights. And today I'm talking with immigration attorney Sarah Ramey. We're discussing a notice of proposed rulemaking on employment authorization for certain classes of aliens, as is listed by the Department of Homeland Security's notice, with final orders of removal. This was published November 19th of 2020. And Sarah, from what I understand, this proposes to largely eliminate the right to work for individuals with a final order of removal. Can you give us a little more information on this?
Certainly. Thank you, Paul. DHS oftentimes cannot remove someone to their home country because that country may be in a state of civil war. It may be run by a dictatorship that we don't maintain diplomatic relations with, or the country may just be uncooperative and not want to assist. This is also a situation that can arise when individuals are stateless. So, for example, the person may have been born in Honduras, for example, as was a case we worked on at the Migrant Center recently, and but never have registered for a birth certificate. So the country had no record that that person was a citizen. And so basically, there's a number of situations where individuals cannot be deported, and DHS determines that they um, will need to be released from detention, right? They may not have even been in detention initially, but typically people are going to be in detention. And then when DHS is determined after 90 days or after 180 days, there's these different marks at which they're supposed to review the case. If they can't remove the individual, they'll typically release them on what's called an order of supervision. And with that order of supervision, they have typically been authorized to work. So Congress has delegated authority to the department to determine when someone can work in these circumstances. And the proposed rule is significant. Thus, the administration is required to go through the notice of comment period and give us, the public, 30 days to comment. The administration has basically determined that this uh, authority is going to be limited more than it is currently in practice. So at the moment, the Secretary of DHS um, can choose not to remove an alien and grant them work authorization, and can also grant them work authorization if it would be impractical to remove them or contrary to the public interest. So, the first significant thing to know about this rule is that it's going to take away the authority of DHS to provide for work authorization for individuals whose deportation is contrary to the public interest or is impracticable. So, the language that the proposed rule uses that's crucial in this respect is that DHS has to affirmatively um, show that the country is not going to accept the person. So, just to give a little bit of background, Cuba is a country that we have not been able to deport people to at various points in time. Eritrea is another country, Venezuela. So, if these countries are not talking to the United States or otherwise are not moving very quickly in looking at a particular individual's case, that person could be released on an order of supervision and live in the United States for a year, 2 years without work authorization because that country has not affirmatively said that they will not take that person back. Um, I think it's pretty safe to say that in all the cases the migrant centers worked on where this issue is at play, the DHS is just waiting to hear back, right? They haven't been told directly that the person will not be able to go back to their country. And so, in effect, this proposed rule is basically going to deny work authorization to everyone in this circumstance. So, we're looking at about 24,000 people who will no longer be able to support themselves and their families.
Wow, that really gives us a lot of background information. Now, now I'm going to read this directly. I'm going to quote from the proposed rule itself. But from what I understand, this is the aim. of the proposed rule to, quote, reduce the incentive for aliens to remain in the United States after receiving a final order of removal and to strengthen protection for U.S. workers. How likely is it that the proposed rule will be able to accomplish these things?
It's very doubtful, Paul. So, first off, um, there's no evidence provided by the proposed rule, no sort of fact based analysis that the administration undertook to suggest that by denying work permits, somehow that's going to force people to go back to their home countries. We've worked with a lot of asylum seekers. That's really our specialty at the Migrant Center. And they can't go home. Their lives are at risk. Just in a brief aside, the Department of Homeland Security is saying that they are going to continue to work to deport people, even if they're released on order of supervision, and that they expect that could happen in a year's time. Right? I mean, this is very hypothetical, and completely ignores the fact that sometimes these individuals have pending cases and an active stay of removal. So this could be a case, for example, that was denied by the Board of Immigration Appeals and is now at the federal circuit courts, where the federal court, or even sometimes ICE itself, has determined that that person qualifies for a stay of removal while the litigation is pending. But they technically would have a final order of removal. And so this rule would prevent them from working during the time that their case is pending. Of course, someone in this circumstance, even if they're not an asylum seeker, is going to want to stay in the United States and not self-execute that removal order so that they can pursue their legal options. The second piece of the goal that you mentioned of this proposed rule is that somehow U.S. workers are going to benefit. And basically, the only thing that the administration is saying here is that, well, when these 24 plus thousand people lose their jobs, then American workers or others authorized to work in the U.S., such as legal permanent residents, DACA holders, etc., will fill those positions. This is speculative at best. Number one, the other individuals in the labor market that may be searching for employment may not be qualified for that position or interested in that position. The other thing that the administration doesn't consider is sort of the full cost to the employer. So the rule requires that for renewal applications, the employer is part of the E-Verify program. And this program has been found to be very problematic. It is an optional program, partly because it's viewed as very problematic. And what this program does is it requires that the employer verify the work authorization of each person. Now, employers already do this when they require that individuals fill out the I-9 form. But the E-Verify program then asks that the employers check this against their database. And if there's not a match between all the records in the different departments, then they send a no contact letter. And these letters have been used to basically fire U.S. citizens as well as others. So forcing employers to use the E-Verify system is going to potentially be harmful for everyone involved, not to mention that it requires the employer to take on this extra burden of registering, signing up for this program and maintaining this program. And it's unlikely that employers are going to just want to jump on this bandwagon simply because the administration is basically twisting their arm. So what we're looking at two, issues here. The first is sort of the likelihood that employers are not going to want to sign up for this program if they haven't already, right? And then the additional costs that they would have of searching for and hiring and training replacement workers. So, that's going to be a cost to the employer, which they're going to have to pass on to the consumer, or, hire less staff, which is going to, again, potentially impact the community overall. The individuals who are going to not be authorized to work, in many cases, are going to still have to find employment, right? They're going to need to support themselves and they're going to need to support their families. So a lot of them will probably end up taking under the table, uh, jobs that don't require work authorization. And these are going to typically be, lower paying positions, sometimes under minimum wage. And, sometimes are also going to be in situations with other labor rights violations. So this rule basically is just creating a system that's going to depress the wages of the different industries overall, right? So that's going to affect all workers, it, and potentially be very harmful for everyone from the employer to the immigrant to the other workers in the community.
Wow, that is a lot of information, and that really helps to let us figure out where this proposed rule is expected to go and where it would probably actually go to. But my next question, it does kind of talk about the employment authorization, and specifically the proposed rule basically states that if someone is subject to a final order of removal, but they are able to apply for employment authorization, the DHS has determined that their removal is impractical because all countries from whom DHS has requested travel documents have affirmatively declined to issue such documents, and the aliens established economic necessity. This seems like it's kind of over the top as a requirement for these individuals to go through. What would you say if someone would suggest that this was punitive, in fact, for them?
Well, I would certainly say that this is a punitive rule in several respects, because first, it doesn't really achieve any legitimate government outcome. And so, really, anything that it's doing that's going to be harmful is, in effect, by nature, punitive. And whether we're talking about the administration's, estimate of losing over $1 billion in earned income, or the hundreds of thousands of dollars for the employer. Basically, this rule has a couple of elements that I'll just highlight, but that by no means are comprehensive of every punitive problem that the rule presents. One is that the administration says, well, we realize a lot of people are basically no longer going to be able to support themselves and stand on their own 2 feet, but that's sort of okay because they can rely on their support network. And the administration says that's could include family members, community groups, nonprofits, or third-party organizations. And as someone who works and has worked in the nonprofit field for quite a while, um, that's not very practical for a couple of reasons, right? One, nonprofits, are stretched thin as it is to meet community needs. If nonprofits are asked to then pay the wages of someone who's a able-bodied individual and is willing to support themselves, instead of using that money to support indigent asylum seekers like we do at the migrant center, or pay for food or housing for the homeless, that's going to have a huge ripple effect through our communities. And so rule is actually very punitive to the community groups, directly, and then through them all the people that they serve. This is also going to be, of course, a huge hardship for the families. So even if we have a family where there are two breadwinners, putting all the financial responsibility on one person is going to be very hard. So we're looking at a situation where the mother or father may have to take 3 jobs and not have any time to spend with their children. The children are going to be taking on a lot of the stress of the family as well, right? And so there's also this, potential psychological and sort of familial hardship outside of the monetary aspect that the administration is addressing, right? And they're not considering, sort of the longer term and effects of this proposed rule. And so, we really think that this rule should be withdrawn, but definitely needs to be thought through more carefully, and and then once this, the evidence and the analysis has been done by the government, then it needs to be put forward again, to the public to review and comment on it.
Wow, it seems like there are really more underlying issues here than are apparent on the surface. Um, Kind of continuing on that same line in regards to cost, um, the proposed rule actually states, and this is another quote, that it could result in lost earnings for those no longer eligible in the range of over 600 million to almost $1.5 billion. Clearly, this is no small amount of money. But I mean, besides these very specifics that the proposed rule itself has laid out, what are some other costs that we might expect from this ruling if it is enacted?
Yeah. So, first, it's interesting to read through the language of the rule because um, the government, in calculating these costs, is basically going off of the minimum wage. So there are some, higher earners out there, that are, that income is not being fully considered. So you know, we've talked a little bit about the lost income. The other kind of side of the coin is the lost tax revenue to the federal government from that income. And this is huge. I mean, potentially, right? So that the government has said in the proposed rule that we're looking at anywhere between, and I'm just going to round the numbers here, but anywhere between like 94 million and $229 million in lost income to the federal government. What does that mean? That means less federal funding for schools, for roads, for public parks, right? So this is, again, it goes back to cost to the whole community. The proposed rule doesn't look at the cost of lost income to the state or for local taxes that would be related to those wages being earned. And so, just from a monetary standpoint, this rule is really quite significant. The other thing that's worth mentioning that I think you were alluding to a little bit earlier in our conversation is this increased burden on the applicant for work authorization. So those who are still eligible to apply, in terms of the extra process of adjudication, right? Because we're no longer looking at a discretionary process. We're looking now at a process where people have to prove economic necessity, which I would certainly agree it doesn't seem like it should be needed, right? If a person, it's just extra work for the applicant and extra work for the U.S. government to adjudicate that. So there's a separate form. It's the I-765 WS, or which stands for worksheet. It is a fairly short form on its surface, right? But the individual is going to need to then get all the data and support, getting documents to back that up. And this is really this, this is really in line with what the current administration has been doing across the board in making the application benefit process through USCIS, U.S. Citizenship and Immigration Services, which adjudicates these petitions. It adjudicates, naturalization petitions, DACA petitions, residency, TPS, etc. The processing wait times were about 2 years ago up 46%, and I just saw a number that they've gone up slightly over 100%. In the last 4 years. And the reason why everything has slowed down so much is not because there's been more applications. In fact, I believe there's been less overall, but because the administration has put on all these extra burdens on both, the applicants, but also ultimately on the federal government in their adjudication process. So this is concerning because it means it's going to take longer for people to get an answer. It's going to be longer before they can get into the workplace. And it's going to slow down things across the board, not just work applications, but potentially those other types of applications that I mentioned. One of the things that would be funny if it if it weren't so problematic in the rule is the government's estimate is going to take only 30 additional minutes to gather all the evidence and fill out all this extra paperwork and become familiar with the forms. Now, I can guarantee you, having applied for work permits for immigrants over many years and having an understanding of what's involved in evidence gathering, that is far, far off. So the individual is going to have to additionally show that they have this economic necessity, right? So if they just want to work because it's a human right to be able to work and do your profession, that's not going to be enough, right? But let's say they will be able to prove economic necessity. They're going to have to probably gather financial information for the whole household, among other things. They're also going to have to show now that they're complying with the order of supervision, which means they're going to need to get a copy of that. They should have it, but in some cases people don't, or they don't have the proper signature lines and notations filled out, which would mean another trip to ICE. They're going to have to show a listing of all their criminal history, which they're getting biometrics taken. So USAS will have access to this information anyways. But that can be very complicated for people, especially if, let's say I had a DWI in a different state, 10 years ago. To go back and find those records can be very complicated for people. So, with the other kind of last point I'd mention on that is people are going to need the assistance of lawyers much more than they did before. So there's another cost. It's going to take more time to find attorneys, and then that's again just going to really make this whole process prohibitive, which I think is ultimately what the point of this was. So this is going to affect people who have been in the United States for a long time, because there are people who've lived for many years under orders of supervision. It's going to affect people who were recently released from detention because they were medically vulnerable due to COVID-19. And it's going to affect, a lot of people in many other situations in between.
Wow, that's really amazing the way you've laid it out there. It clearly shows that there is a lot more cost involved that goes beyond anything that's mentioned in the actual proposed rule. Wow, thank you, Sarah, so much for your insight today. I'd like to thank you all for joining us on our podcast and invite you to continue to follow our podcast, and please submit your public comment. You can do so with a quick hyperlink at migrantcenter.org/advocacy. And there you'll be able to see our public comment. And there is a hyperlink in the first paragraph that lets you go directly to the public comment site. So please do that. And thanks again for listening. Goodbye.